just let me know. I mean, I can shout for these people. It is on.
Are we ready to go? All right. Hi, everyone. Welcome back. Thank you for being such active and interesting participants all day long in the series of interesting conversations we've been having. So as I mentioned at the beginning, this has kind of become a tradition here at this conference to have Commissioner Julie Brill. I told her once, and I think I meant this as a compliment, I hope you took it as a compliment, that she's a member of the house band.
Oh, yeah.
That
Especially if I get to play the tambourine.
an important part of kind of this community that's developed around this conference and the community of kind of privacy scholars, academics, and practitioners around the world. Again, our tradition is not to say too much, and I'm not going to give you the formal biography. I commend it to you, especially if you don't know the work of Commissioner Brill. But I can't resist kind of editorializing a little bit, just because we talk a lot at the school about public service and public servants. And to me, when I'm thinking about ways we might inspire our students to enter public service, I always kind of have you in my mind.
Wow, that's nice.
And frankly, again, editorializing a little bit, I think there are some public servants who really are thinking about the next industry job that will then bring them back into government, that will bring them to the next industry job. So Julie Brill has been a civil servant for a long time, not just at the FTC, but in 2 different state attorney general's offices. And more than that, kind of embodies this like really wonderful commitment to doing right by the citizens, really, more than anything else. And as a lot of you know, I spent a year at the FTC, and it was really such a privilege to be able to work with Julie on almost a day-to-day basis, and to see this kind of public service, aura that she brought really go to her attorney advisors and to the staff and the bureaus and everything else. So it really is a privilege.
It's really sweet of you to say. Well, I felt the same way about working with you. We were thrilled to have you, and it is true, I will never get a job in industry, I am sure. But no, I mean, but you really, it is true, you do need to do these jobs. You need to, I believe, do the jobs by thinking who is not in the room.
Right.
Who, when you're, all the issues that you deal with, I've been doing it for over 20, for a really long time now. I think about who's in the room and who's not in the room, and the folks who are usually not in the room are the consumers and citizens. They're not there, right. So someone needs to be representing them.
Right, and that's great, and you are there for them. So let's suspend the discussion about kind of consumer ethics and things like this for a few minutes. I want to ask you questions about that too, but let's continue the kind of conversation we've been having for many years about the FTC generally and about its privacy mission in particular. I think you told me that your favorite recent quip about the FTC was Bryan Calo?
Oh, that was, yes.
He said, happy 100th birthday, you don't look a day over 30, is that what it was?
40. He said, happy 100th birthday, FTC, you don't look a day over 40. I thought that was fabulous.
And so the FTC has just celebrated its centennial. It's amazing that this agency, which has really gone through lots of different phases and been lots of different agencies, celebrated the centennial, and it's given the agency the chance to have lots of parties and observations of this, which I'm guessing has given you personally some time to be introspective, to think about your place in the long arc of this agency. So tell me what these reflections have led to you about your thoughts on the agency.
Yeah, so it is amazing that we're 100 years old. And when you think about it, I think one of the reasons why we have been so vital, especially lately, I mean, look, everything goes through ebbs and flows and everything goes back and forth. And the FTC certainly had its issues over its 100-year history. But I think one of the benefits of the FTC is the flexibility of its foundational law. There are lots of sector-specific laws that we enforce and lots of things that we do, whether it's COPPA, Children's Online Privacy Protection Act, HIPAA, and that's a GLB, FCRA, and this is just in the privacy space. There's lots of other sector-specific laws. But when you think about it, our foundational law, which is unfair and deceptive acts and practices and unfair methods of competition are not allowed, that is such a flexible law that it allows us to use it in lots of different circumstances. And that's really what the design was. When Brandeis was thinking and Woodrow Wilson were thinking about developing an agency that could really think broadly, they were thinking, well, we need to give it a foundational law that will be broad. Think about how many other agencies have such a broad law, and there really aren't that many. The only one that I think has been created in a somewhat similar way that I'm actually aware of at all is the CFPB, which has the ability to proceed against products now that are unfair, deceptive, or abusive. So they got that additional authority in financial services, but it took a huge financial crisis to make that happen. So I think that's one of our strengths, and we have been able to use it in some really interesting ways, especially lately. But that was always the intent. One thing that I don't think the founders originally thought about was our going into federal court. That was something that came about through an amendment to the FTC Act. We got our 13B authority, which allows us to not only use our administrative process, where I actually, along with my fellow commissioners, sit as a judge, but we also can bring cases in federal court. And we do that not only in consumer protection and privacy, but also with respect to competition. And it's an incredibly important new authority. So that has just added to our power. But what we've been able to do with our unfair methods of competition authority on the consumer protection side is, a lot of people are now looking at us as one of the premier, if not the premier, law enforcement agency when it comes to technology issues. The Washington Post calls us the new technology, the technology cop in Washington. One of our friendly critics, Jeffrey Mann, said that the Federal Trade Commission should be redubbed the Federal Technology Commission. And I say that with all due respect, Jeff. I think it's a great quote. Because we're doing a lot of important work, not just in the privacy space, but also with respect to all sorts of uses of technology, whether it's in-app charges, that is, charges that consumers are experiencing in the context of apps with respect to their children. So it's kids' purchases with inside apps, whether it's cramming or throttling. We just brought a very important case involving broadband speeds. So we're doing a lot of work in the law enforcement area involving high tech, and I think that's, frankly, I think it's what was always intended that we would do because of the broad flexibility that we were given.
That's great. So let's then zero in on privacy, and let's
Sure.
talk about the agency's kind of role in privacy. For me, the biggest recent development was probably the trustee case. Mm-hmm. And actually, the trustee case, I started thinking of echoes of that as I thought of the last panel, right? If we're talking about finding bodies that can certify ethics, we have to learn lessons about past attempts to do similar things. So I don't know if you have any comment on that case in particular, the settlement, or more broadly on the kind of the state of the privacy mission of the FTC today.
So I do have, it won't be surprising to you to hear that I have thoughts about both of those things. So just briefly, privacy is one of our top priorities. I mean, it's along with data security, they go together, and we'll talk about data security in a minute, but privacy has been a huge priority of ours for the last 5 or 6 years, and it actually extends back even further. It's something that is not just being focused on by the FTC, but it's actually of worldwide importance now. I mean, you look at some of the stuff that's going on in Europe, you look at what's happening at the state levels in terms of California legislation, you look at state AG activity, and then you couple that with what we're doing at the FTC. I think that you're seeing a very broad effort to focus companies on their data collection and use practices. And frankly, I think that companies are getting the message. This conversation, which is really that we're having here today, which is really at the forefront of what some companies are doing, is showing how important the conversation has been. And we're actually starting to see competition on privacy now, which I think is a really interesting development. And I think a lot of this is because the enforcement work we do, the discussion that's happening worldwide and the discussion that's happening in the States has just raised privacy to a very high level. we've done, and I could talk about some of our my favorite cases, whether it's Snapchat, which I thought was a really important case, where we brought an action against the service that many of these students undoubtedly use. I know my son really uses it. He refuses to snap a picture of me, though, and send it out on Snapchat. I have no idea why. But that was an incredibly important case. Or whether it's some of the stuff that we did, like, for instance, with Fandango and Credit Karma in the data security context, which are companies that didn't even suffer a breach, but we felt had vulnerabilities that could have deeply affected consumers' credit reports and credit card numbers, and so we brought actions there. I mean, we're bringing some incredibly important cases. So I think privacy has definitely risen to a very high priority, and I think that this is good. I think we are getting the attention of C-suites, which is really where the conversation needs to go, and it needs to become less of a legal compliance issue and more of a risk management issue. So I think we're starting to be successful. There's a lot more work to do, and we'll talk about some of that in a minute. Trustee is an interesting case. So I don't know how many of you really know what the trustee case is about, but it involves the Safe Harbor program. Safe Harbor is an agreement between the U.S. Department of Commerce and the EU Commission, the European Union Commission, over a mechanism for allowing data transfers between Europe and the United States that would be deemed adequate, even though the United States as a whole doesn't have adequacy. So companies that agree to abide by the Safe Harbor principles would be allowed to transfer data. They, by agreeing to abide by those principles, are subjecting themselves to the potential of enforcement if they fail to live up to those principles by the FTC. We have brought over 20 cases involving companies that were not living up to the principles or were otherwise being deceptive about whether they were complying or within or without of Safe Harbor. Trustee was playing a kind of critical role in this space because Trustee is serving as a Safe Harbor mechanism to help companies comply with the Safe Harbor principles. So they were a company that was providing certificates or certification that their members were complying with the Safe Harbor principles. We alleged that Trustee had, apparently through a computer glitch that it was suffering from, that it had failed to actually recertify some of the companies within some of its member companies. So we brought an action that its recertification was deceptive. And that was a very important, I believe, case, because what it showed is that we are going to police the policemen, if you will, or sort of police the folks who are supposed to be regulating regulating the company's behavior within a Safe Harbor program. It also showed how important we think the Safe Harbor enforcement work that we at the FTC do is, and we do take it very, very seriously. Now, having said that, I know that there are a lot of people who say, gosh, these cases take so long, and why is that? And I've heard that from a number of people who are undoubtedly tweeting about this, even as we're talking about it. It is. I understand the frustration about how long our enforcement work takes, but put yourself in the shoes for a moment of a company that's facing an enforcement action on the part of the FTC. You want to make sure that you get all your information to us. We want to make sure that we've uncovered every stone that needs to be uncovered so that we are really doing the right thing. Fundamentally, due process takes a long time, and I do think that we have to make sure that companies and we are getting all the information exchanged appropriately. So I think Trustee was an incredibly important case. I think it shows our commitment to making sure Safe Harbor works. I think Safe Harbor itself is an incredibly important tool. There's a lot of discussion in Europe about how to improve Safe Harbor. There are some people who want to do away with it. But I say, as someone who's a lifelong consumer protection person, do not take that tool away from me, because it helps me protect European citizens as well as ensuring that companies are living up to their agreements. So I think it's an incredibly important tool.
That's great. So I next want to ask you a question about North Korea. but not really. But right, given the news this week about the Sony hack,
Right,
okay.
I
And
was wondering
how
how you were okay.
somehow the North Koreans may be involved, but that's not what I want to ask you about.
Right.
I mean, it really does strike me that when we talk about data security, I am struck by the kind of helplessness, like shared helplessness that everybody has about the situation. And so I think I kind of want you to think about and reflect on the FTC's role in the data security cases it brings in terms of what practical impact is this having to these average people who are really, really terrified, or at least confused, or at least in some cases just resigned to this being like a fixture of modern life. And rather than go into the nuts and bolts of Wyndham and all these other things, which I'd love to hear about as well, but I'd like to, is it helping? Like, what should the consumer think about data security today and the FTC's role in helping them safeguard it? Right?
Well, so not only is look, I believe our enforcement work is helping. I think in the absence of enforcement work, we don't really know how much worse it would be. But I do think that the companies, and Sony, look, that was sort of a corporate hack that really hurt, apparently, based on reports, hurt the company itself. But the kind of security breaches that we get concerned about are the ones that involve consumers' information. And this has been the year of data security. I mean, I was on the plane ride over here, I was reading, there was a section in the New York Times yesterday all about data security. I don't know to the extent that any of you read this, but it actually had some great pieces in it, and I highly recommend it from yesterday's Times. Look, I think our enforcement work has been very important to inform the business community that not only will they have to live up to their promises with respect to data security, but we will also bring cases involving unfair practices when it comes to data security. So it may not matter as much whether they make a promise about how they were going to hold consumers' information, but if they fail to live up to reasonable practices, we will potentially bring an action against them. Having said that, we have investigated hundreds of cases, and we've brought, I think now, on the order of 54 or 55 of them. So not every company that suffers a breach is subject to a detailed investigation by us. And as I mentioned a moment ago with respect to Credit Karma and Fandango, not everyone who is subject to an investigation has suffered a breach. We do not play a gotcha game. We're not looking for perfect security, but we are looking for reasonable security. I think, though, in addition to our enforcement work, we are also doing a lot with respect to consumer education. So getting to your point about what can the average person or the average student or whatever, how should they feel about this? We provide a lot of information to consumers about how to avoid becoming a victim of identity theft, how to minimize the amount of information that they give to entities, how to make sure that they're dealing with secure HTTPS and secure protocol sites to the extent that they can. And if they don't know who they're dealing with online, to not give out personal information. There are things consumers can do to try to protect themselves. There are also protections that industry has put in place, for instance, with respect to credit card numbers and credit card hacks, so that in the event that your credit card number is stolen, consumers will not suffer a huge amount of financial loss. And we have advice to consumers, as does the Times, about the differences between debit cards and credit cards, and how consumers may be on the hook for a lot more with respect to a hack that involves their debit cards as opposed to their credit cards. There are improvements in these areas that are going to be, I think, coming online soon. Pin and chip is going to be a critical piece here, and I think the industry, I've been calling for the industry to move to pin and chip for over a year now. I was very pleased when the president issued an executive order saying federal government's credit cards will be moving to pin and chip, and I think that will help move the market here. I think another thing that we can do at the FTC, and I think we're trying to look you mentioned the Wyndham and Lebandy litigation, and one of the things that we're trying to do is figure out how we can be more transparent about what it means to have reasonable security. We've been hearing this from people for a long time. You do these cases, but nobody knows what they mean. Nobody can kind of get into the guts of what you're doing, and we don't know really what's happening when you close a case. Now, I think to a certain extent that criticism was and is unfair. We do give out information when we close a case, but also a lot of companies that we're dealing with really don't want it to be known that they were subject of an investigation, even if the case is closed, because that could lead to harm to them. But we do issue closing letters, and we did just issue one involving Verizon, which I think was very informative about the fact that, as we said in that letter, Verizon was giving out a product, a router, that did have inappropriate and sort of very out-of-date security protocol attached to it. But the reason we didn't bring an action was because of all the other things Verizon had done to correct that and to try to bring consumers' products and the routers up to an appropriate security standard. I want to see us do more of that, and I think we will try to do more of that because we get it. And, we listen to people. That's one of the reasons I come to things like this. I understand that people want more information about what we're doing. And maybe we can figure out a way to give out even more information by not talking about particular companies' names, but sort of, on a monthly or semi-annual basis, saying, okay, here's some cases we've done. Company A did X, Y, or Z. We didn't bring a case there. It's tricky how to do that appropriately in a law enforcement context. But I think that I want to assure people we are thinking hard about how we can be even more transparent in terms of what is reasonable security and therefore what is not reasonable security.
But that specific example you just gave, is that a plan or this is just something you guys are thinking about?
It's not, nothing is definite. I think what I'm trying to say is we're trying to be as creative and proactive as we can, at the same time not being misleading.
Right.
Because we don't want people to hold up a document and say, oh, but you said if we did X, Y, and Z, we wouldn't be subject to an action. But what we couldn't put in there was, yeah, but you also did E, F, and G, and that was really a problem. So in a law enforcement context, it's very tricky. But what I'm trying to say is we're trying to think creatively about what we can do here.
So when we were talking today, we said there will be not enough time to talk about all the topics, and we're almost out. So I'm going to make two executive decisions. One, I'm going to delay questions for the commissioner until she's graciously agreed to join the next panel as well. And so I'm going to get the last question, and I'm going to kind of thank you. I'm going to jump to asking you about the discussion we've been having all day.
Yeah.
And the topic that I haven't heard discussed much today. And I expected that it may or may not be relevant, we'll see what others have to say as well, is whether any of this reflects a kind of mindset issue, whether, startups today, especially given the way they're funded, are encouraged to kind of pivot and to fail often, and to experiment with different business models, which kind of leads directly, maybe, to this sort of A/B testing mentality of everything. I guess question one, as a descriptive matter, does that sound true to you? And question two, is there a problem with that? Is there a concern with that? Is there something we need to kind of worry about because of that?
Yeah, it's a really interesting question. I do think that there is, I can call it a Silicon Valley mindset, but it really is obviously much broader than just, one particular geographic location. But there is something that's going on in the tech, startup community where they want to launch something, usually on a very small scale, see how consumers are interacting with it, and iterate, right? And test and move, and that's been actually an incredibly successful model when you think about it, in terms of developing products that consumers love and have been using and that have been perfectly appropriate for a long time. It does sort of potentially clash with a sort of lawyer's mindset or a regulatory mindset. And the question is, some of these issues do involve ethics, as we heard on the last panel. Some involve things like best practices, so that we're not necessarily talking about actual practices that are illegal or that we might bring an action against at the FTC or that a state AG might bring an action against, but it still doesn't feel right. And part of that is because a lot of it, and I don't need to talk about any particular company because I'm not, it's happening behind the scenes. Consumers don't realize it's happening. And the question is, to what extent should consumers be informed about it? And it reminds me a great deal of the discussions that we're having at the FTC and that I care very deeply about with respect to big data analytics much more broadly. Whether, some analytics projects are really fabulous and could potentially lead to some great beneficial uses, but some could lead to what I will call unfair uses that could wind up into a discrimination kind of concern, or something that's closely akin to that. Sort of almost in a civil rights bucket. So how do we deal with those issues, especially since much of the analytics is happening behind the scenes? How do we inform consumers appropriately? How do we give them appropriate choices? These are tough questions. We heard some people talk about that. But at root, I do think there is there's a mindset issue. There's also a scalability issue, which I know we'll talk about in the next panel too, which is, it's one thing when, Facebook, heard criticism, we're going to hear how they've reacted to it. Google has had to react a great deal to, for instance, the right to be forgotten, just as one, an example. They set up a whole regime around that. But what do we do with this, again, going back to the startups, do we really expect them to bring on board, a consumer review board and, an IRB-like function? So I think we need to come up with a multiplicity of solutions that are going to focus even startups on sort of the ethics of what they're doing. And it might be educating engineers, it might be getting into engineering schools, where I've also gone and had discussions about thinking about these things from the beginning. Privacy by design, but maybe we need to start thinking about it more along the lines of fairness by design, not just privacy by design, because really privacy, in my view, is a subset of these larger issues.
Well, great. Well, thank you so much once again for joining us, and please join me in thanking Commissioner Bell. All right, so if we time warp back to this morning, right? I wish I could just do the sound effect. I think I remember saying something like, "I hope today isn't just about one company." I think we've failed in that endeavor. I think there's been a lot of scrutiny and discussion about one company, and in particular, a lot of people, especially on the last panel, have talked about something we haven't formally described, which was a month and a half ago, Facebook came out, maybe it was longer than that, and said, look, we've heard your complaints and we've responded and we've revamped our internal review. And I know a lot of the experts in the room know all about this, but some of the others may not. So Rob Sherman actually delayed his flight to give us 5 more minutes. So thank you, Rob. And while Rob's coming up to get ready, I'd invite the next panel to come up as well, because we're going to jump right into it. But Rob, I've asked him to speak a little bit about the internal review. Maybe if there's one really quick question, he can take that as well. But this is kind of free-form jazz odyssey, and I want to hear what Rob has to say.
Yeah, absolutely. And thank you for the time. This is something I hope we would cover a little bit in the panel, but we had a lot of interesting other things to talk about. So it's good to have an opportunity now. So I think, as Paul said, after the emotional contagion study came out, I think it's fair to say that we hadn't anticipated the reaction that we got. And in part that was because it was older research that was published later, and I think also there hadn't been a lot of discussion in the community at large about these issues. And so we've obviously had a lot of conversations with a lot of folks since that time, and even dating to prior to that effort, prior to that publication, we'd had some work that we've been doing internally to come up with more robust and improved processes. But I want to talk at a high level about sort of where we are now, and then I'll talk just briefly about where I think we'll go from here. But as we think about research at Facebook, it's an issue that is doing it well and do it both in terms of getting accurate and reliable data, but also in terms of doing it ethically and doing it in a responsible way. It's our responsible as a company, but we also tell individual people at the company that it's their responsibility, just like they have other responsibilities for privacy or other things. So what we've instituted first is a training program that all of our employees, regardless of what their job is, have to go through, that is in addition to privacy and security training that we have that focuses particularly on research issues. And then there's some additional in-depth training that people who have jobs that touch on these issues more, particularly our data scientists and our engineers, have to go through. So that's something that we do just across the board to educate people and make sure that they're aware of these issues and aware of the discussion that this group and lots of other people have been having. We've also established internal guidelines for the research that we do. And the guidelines focus on key questions that make research, that distinguish between sort of the run-of-the-mill kind of research. And I think we've had a lot of discussions earlier about how do you draw lines, how do you figure out what's concerning and what's not. And I think one of the things that has been I haven't heard it as much today, but has been a big topic of discussion is what's in and what's out. What do we mean when we talk about research? And so, so I think, we've heard in some places that research means things that you publish in an academic paper. And so the earlier panel talked a little bit about that. I think the way that we've approached it internally is that our process applies to all of the research we do, regardless of whether it's ultimately going to be designed for an academic paper or not. And I think that's important to maintain consistency, and also because the approach that people who use our site, independent of sort of whether they're academics or not, will have, it is going to be consistent regardless of whether we want to submit it to a journal at the end of the day. But the guidelines that we've established focus on key questions that can make the work that we're doing more sensitive. So things like, are we looking at sensitive populations? Why are we doing the work, and how it's going to be used? Are there sensitive issues that are being confronted? I think emotions are obviously an example of that. And are we doing external collaborations where there's any work that might involve collaboration with somebody outside? Obviously, if there's data, we want to look at de-identification, those sorts of things. So that's all part of it. And that ties into not just the responsibility that individual researchers have, which we tell them we have, but also a review process. And you heard a little bit about this earlier, and I think Paul mentioned it as well. But what we've done is we've designated a single senior researcher in each research group at Facebook that's responsible for sort of overseeing the research that happens within their organization, and particularly those that trigger the kinds of issues that I talked about earlier. The idea there is to have a particular person who's a subject matter expert and has an understanding of the kind of work that group is doing. I think there's some additional components, but we thought it was important that somebody have a substantive context in the research as they're evaluating its ethics and whether it's something that we want to be doing. But in addition to that, we've constituted a cross-functional review process that includes people from around the company. It's modeled in some ways on our privacy review process, which also is a cross-functional effort that looks at things from a variety of different angles, and we found it to be very successful in terms of picking up issues and figuring out what we need to do and where there are concerns that we need to work through. That group includes people from our engineering, research, policy, legal, and privacy organizations, and obviously it's in addition to other reviews that we have. So some of this research, for example, might trigger privacy review with our existing privacy program. So it's in addition to that, not separate from that. And then there's an escalation path to senior management, so it's overseen by our chief technology officer, and then there's an escalation if there are issues. I think we've been. I think our experience has been that people are very collaborative and really want to do the right thing here, but we have the ability to escalate things if that becomes an issue. One of the things that I heard on the earlier panel that I wanted to address is people had asked, are we going to publish the guidelines themselves? For right now, we've decided not to do that, and the reason is largely because the guidelines are a work in progress. I think there's still a broad discussion outside the company and inside about what are all the things that we need to be thinking about. And so we intend to improve it and evolve it over time and to participate in more of these discussions. That said, I mean, I heard some fairly, some persuasive points in the discussion earlier, and we're having those discussions internally. So if people have thoughts on how we should think about that or when we should talk about that, we're certainly interested in hearing about that. But for right now, we've decided to continue to see how the process works internally before we do that. And then the last piece is transparency, and this is something you heard me talk about earlier on the panel this morning. I think we believe pretty strongly that one of the ways that we can be held accountable is if people know what we're doing and people can have reactions. I mean, hopefully people will be comfortable with the work we're doing. And in one case that we've talked about a lot today, they haven't, and we got that feedback and we're able to make improvements based on that. But we have now a website that includes all of our research publications, so you can go there and see the work that we're doing, and it's not just in sort of behavioral science research like we've been talking about largely today, but across the gamut of the kinds of things that people do at Facebook. And so those are research publications, but I also mentioned on the panel that we're doing that not just for research publications. So, for example, when we make improvements to newsfeed and the way the way that feed is curated, the way that we make decisions about how to rank things, that's also work that we want to be transparent about and let people who are interested find out about it. And so we've been publishing regular updates on those issues on our website. And then finally, I think we've committed to having this discussion. I think a number of people have said it might have been easier for this to be a discussion about Facebook without Facebook. And I think it's really important to us and to me as somebody who thinks about these things that we continue to have this dialogue, and I think we're sort of at the beginning of it now, and I don't think there's consensus on what the right solutions are, what everyone should be doing, but it's important to continue to have these kinds of discussions and figure out, how can we make sure that we're getting the benefits of not only the services that people are using like Facebook, but also making sure that we can understand well what people want and do that in a responsible way. So it's a discussion that we think is important and we're continuing to engage in. So that's sort of a high-level overview of the process. I should say we got there with a lot of discussion with a lot of people, including some people in this room, and want to continue to have those kinds of discussions because I think this isn't something where we have the answer and it's over, but we need to continue to explore those issues. On that topic, I'll make a plug. We're hiring some people to work internally on research ethics issues. So if you are interested or know somebody who might be good, in all seriousness, we're looking for really smart people who have thought a lot about this and can help us move forward both internally in terms of driving a broader discussion about it. So if people are interested, please let me know.
So that was very detailed, and thank you again.
Yeah.
If there's time for like a clarification question, if there's something that you still need to know or want to know. Okay, one quick question.
Yes.
Any plans to include anyone outside the institution on the review panel? And also, there have been rumors that Conf was approached to have a role, and I just wondered if you could comment on that.
So. Sure. So we've talked with a lot of people outside the company about sort of what our process should look like, and and how we should be thinking about it. And so, that may have been what you've heard about, but not necessarily for a particular role in a particular panel. I think for where we've sort of landed is again modeling it after existing processes that we have. That we don't have an external person sitting on the review group, and I think that that's been very successful for us. I mean, I think one of the reasons why you'd want to do that is if there's not a lot of dissension within the organization, or people don't feel comfortable saying no if somebody wants to do that. And I think we've felt good that our process internally, both on these issues and on others, has led to that kind of discussion, and people have had a really robust debate, and we've come to good places. And I also think even if there's not a formal role for somebody sitting on and reviewing individual proposals, having an external dialogue is something that we've continued to do, and I think we've done in other areas of our business as well. That's really gotten us good feedback from, frankly, people that aren't connected with the company and don't have any stake in whether we make good decisions or not, or won't have to put their name on it at the end, but who can say, this is a really good thing, you should do it for this reason, or this isn't a good thing and you should change it in the following way, and that's been really useful.
So, although Rob did delay his flight, he isn't able to stay throughout the length of the panel. Otherwise, I would have twisted his arm to sit on it.
I have another chair up here.
So I'm going to hand it over to the panel, but join me in thanking Rob.
Thank you.
I'm Nicole Day. I am in the second seat because it's the last panel and I want to keep you guys on your toes. So I like to think of this last panel as kind of the what is next panel. And this is the lawyer panel, as we were referred to earlier by Paul. So I'm Nicole. I graduated from CU Law in 2010. I got my LLM in IP and Information Technology in 2011. And I am a lawyer at Holland Hart here in Boulder. So if you're a student and you want to come talk to me about law firm work, please do that. I don't see many students. I guess it's finals. So yeah. Scratch that. So this panel, we're going to talk about, we've talked a little bit about today about kind of what companies should do in terms of internal review. Should that look like an IRB process, private companies versus universities, and what that process should look like? That's the kind of next step that we want to talk about here. What are the procedures that private companies should have in place? Who should be involved in the review process? Is there a place for law here? We'll talk about that. And kind of what role should law enforcement play? So on the panel, Bryan Calo, who we've met, Julie Brill, Omer Tene, and Jason Haislmaier. And I suggest, again, for purposes of time, take a look in your little packet for information. We're running short on time. So I want to turn the panel over to Omer for your presentation.
Yeah, thanks, Nicole. And before I start, I want to thank Paul again Paul and the students for putting together another really spectacular event. And I have to say that Paul has this incredible skill of identifying the issue, not only of the day, but also of tomorrow and the next year, I think this enabled you to have the President of the United States keynote the last one, and this is certainly, a hot issue now. So, congratulations for this conference. I told you it's my favorite academic privacy conference by far, and I really meant it. And we take Paul's instructions seriously. Last year we made a fantastic hire here, Ariel Brown, and we certainly intend to continue this tradition. So thank you for that too. Turning to our issue, I think we're talking about situations where we have legal but sensitive uses of data. And clearly there needs to be something here beyond just the law. So one sort of situation we talked about a lot here is research, and we talked about Facebook research or OkCupid, and of course there are many others. Another context for this, I think, is where we see innovative or actually out of context or surprising data uses. And the example that Jules, who is my co-author, maybe I should have said at first that I'm actually presenting a paper that we are writing, which is titled Enter the Philosophers, and then there's something else. Like I always try for the part before the colon to be really captivating, and then it sort of fizzles out. Basically, the whole article looks like, it's a decline. So Jules always gives this example of the Facebook newsfeed, actually. So I'm sure many of you don't even remember that before it was introduced in 2005 or 6, when you got on Facebook, what you could see is actually your face. So you saw your profile, and so it was even more self-indulgent than it is now. I mean, if that could be. And then they introduced the news feed, and suddenly you started seeing, things that other people, your friends or friends of friends, were posting. And at first people were taken aback and said, oh, this is terrible. It's a privacy invasion, and you're broadcasting our stuff. And then, you started seeing, it's interesting. So he's dating her, and his kids are doing this, and they're traveling there, and it's great. And, now we can't even imagine the world without the newsfeed. I mean, that's what Facebook is all about. But when it was introduced, it was disruptive. And certainly situations where data use is manipulative, and Ryan wrote the article in this on digital market manipulation. So like Julie said in her talk, it's beyond privacy, it's about fairness. So I think in these situations, law plays a role. But it comes short. It can't address every micro situation. And, we've talked about, the third panel talked about the shortcomings of consent. Like if Facebook had another sentence or two in their privacy policy, and maybe it was there all along, I don't know. And in fact, it's not so interesting, this discussion of what it said there or not, because nobody, cares anyways. And certainly nobody knows. I'm not sure it would have helped. Plus also, you need to look not only at the risks and the harms, but, you need to weigh the countervailing benefits, and that might not be captured in the current legal framework, although I think it is captured in the FTC unfairness statement as codified later in Section 5N. These situations are set to multiply. So people mentioned big data and the Internet of Things. So data touches our lives now, not only through the mediated platform online, but also offline, and it's becoming much more sensitive. So I think there are 2 or 3 questions that we try to address in the paper. One of them is which issues should be dealt with under this framework. Another is who should decide. And a third is what are the rules of engagement? What are the rules for deciding? And I want to start with a few words on who should decide. And I want to quote Zeynep in the first panel of the day. A few of the things she said is, first of all, a trust us model can't work because of information asymmetry, because of it's opaque. The question now of whether Facebook has an external person on their board, I think, illustrates that. People want some insight into what's going on there. Zeynep also said that throwing darts in the dark isn't the way to do it, and I think that's probably everybody would agree with that. And she also said that if she'd been asked before, she would tell the researchers at Facebook how bad an idea that specific research was, that people really feel protective and strongly about their feed, and then he sort of meddling with it would raise pushback. So, you know, one solution, I guess, would be for Zeynep to decide. But I'm not sure how that scales. So who should decide? Who do we basically hand, the Belmont principles or the new and improved Belmont principles to? And I think traditionally in the corporate setting, it was a lawyer or, some conscientious lawyer, hopefully, or someone from the CSR side, the corporate social responsibility, or maybe the chief privacy officer or the PR folks who said, listen, don't do that because it will be perceived badly. The press will react. In government and academia, we have IRBs. But as we heard throughout the day, it's not clear that it's a good fit for the business environment. And I want to quote Ryan, who wrote in that Stanford Law Review paper about the consumer, I never remember how you call them, consumer privacy review boards, maybe?
Sure.
Because we wanted to rip off the title, but I can never remember it. So we called it something else, like an ethical review board. So you write there that subjecting companies to the strictures of the Belmont Report and academic institutional review would not be appropriate. Firms must operate at speed and scale, protect trade secrets, and satisfy investors. So that's maybe not a good idea. But clearly this group, which gets to decide on the ethical sort of extra legal issues, should have stakeholders who are not, compensated, for example, based on marketing or sales, right? That would not be a good idea. And there needs to be some balance between having insiders and outsiders. So here, for example, if you have a strictly internal board like Facebook currently set up, you have questions about independence. I mean, at the end of the day, everyone who works in a corporation, even if they're in compliance or audit, report to the CEO, and the CEO cares about the bottom line. And you have questions about transparency. On the other hand, if you have purely external review boards, like some companies already put in place, so Google have the right to be forgotten sort of star panel with like big figures from different institutions, and Palantir, which is a big data company, has the civil liberties review group, which I have to say, I'm on myself. That's also an external group. And the problem there is that these people are just that. They're external. They're not in the processes. They only see what is presented to them by the company. And, you know, they might not be knowledgeable enough about the inner workings in order to be able to navigate these processes or decisions. So it probably needs to be some mix between the two. We heard in some of the panels before that there are concerns about diversity. So the common rule, for example, requires at least one person who's not a scientist. Jill Dupree, who was a speaker, I think, on the second panel, emphasized the importance of gender and racial diversity, so you don't have a group of 12 white men deciding on these issues. The compensation scheme is very important. So I mentioned, you know, if you just have marketing people, then it's pretty clear where they are driving. If you have compliance people, then, you know, they are compensated differently. If you have external experts, again, you need to structure a compensation scheme which keeps them honest. You know, finally, I think the process is important in and of itself. So just having a process and documenting it, I think, goes a fairly long way, because you can then go back and audit and question and also assign responsibility and accountability to people who've made decisions which weren't optimal. A couple of words about the how, the ground rules. So, you know, clearly I'm not going to solve it now, but some of the considerations or the measures that I think that need to be taken into account, and I'll finish in one minute. So actually, Rob, I think, fleshed out some of them. Who benefits from these, from the research or from these activities or services, and who stands to lose or pays the price? So clearly we need some accounting for weighing and measuring benefits against risks. I know we'll talk about the risk-based approach to privacy. I think it plays some role here. And actually it goes back to the Belmont principle of beneficence, or welfare as it was called, which is all about that, and also the FTC unfairness doctrine, which talks about weighing risks and benefits, also looking at who are the people that are impacted. We also need to check whether alternative mechanisms can lessen the impact while achieving similar results. Because sometimes the results will be so compelling that we might decide to go through with a project even if it has significant impact on privacy. You know, if we can cure cancer or like reduce terrorism, but perhaps there are other mechanisms or mitigating circumstances that we can take. And, you know, you can think about body scanners at airports. There were various technologies, and finally we shifted to one that is less intrusive. Jules and I actually wrote a white paper about conducting a data benefit analysis, trying to weigh not only the risks of a project, but also the benefits, because, you know, clearly if you can cure a disease, the benefits are more compelling than if you can just increase ROI by a fraction of a percent. And then I also want to point out the Belmont principle of justice, which is about distribution. So not just welfare, but also who is impacted. And here, obviously, we need to check whether the research or the activities focus on vulnerable populations, like kids, like minorities, or people with disabilities. Whether consent can be practically collected, or do we need to debrief or inform people in retrospect, at least, like James said about Facebook research. And what are the guidelines for collaborating with academic researchers? So I think I'll end with that.
Great.
Yep.
That was great. Thank you.
Yeah.
I think I want to open it to the whole panel, this discussion. My first question being, So with IRBs, we have regulations that kind of set standards. Do we need regulations that set standards in the private sector? Or should we just, are there issues with going with setting kind of industry type or sector specific standards, not in regulation, but just by collaboration, and letting industries adhere to those standards themselves, kind of self-regulatory conduct? Would that be something that you would prefer to see over actual regulation?
But, I think you also need to be realistic. If by regulation you mean legislation, then clearly, we're not going to get it anytime soon. And then the second best solution, if you consider regulation the best solution, would be industry groups and self-regulation and some industry ethics boards which will set ground rules. It's better than not having anything in place.
And Ryan, you had written in one of your articles that the problem here is an issue of transparency. Facebook has said it's going to adopt a set of review principles, but that it hasn't yet shared those guidelines. Do you think that, we should say, yeah, company X will trust you to adhere to specific guidelines and that's that in terms of research, or should they be required to share their guidelines collaboratively?
So I think, one of the things we're talking about is how exactly should these mechanisms look. One of the sets of questions has to do with whether there should be external reviewers or they should be internal. And another has to do with whether you should publish the criteria or keep it close. And we're casting about as though there were absolutely no models here at all, I think, mostly. I mean, we're looking to the Belmont report and IRBs and so forth in recognition of the fact that this is no longer a conversation about control over personal information as privacy has been for a long time, but suddenly it is now an issue about the sort of control that governments and companies can exert over you by virtue of having information about you. And that leads us into a kind of interesting, ethical, more full territory than I think the control over personal information as a paradigm allowed. But again, I think that what Facebook and others need to recognize is that privacy is a human right on par with free speech or something like that, right? And if we think about privacy as a human right on par with free speech, we start to realize that actually there are more models than we might assume. One of which is think about the way that companies deal with and talk about censorship in the United States and outside of the United States. So think about China tells Microsoft to shut down a blog. Microsoft has principles in place and a review process in place for that, and they publish the principles. And they don't ask people outside the company, as far as I know, right? That's because we understand the free speech as a human right, and we have sort of ideas about it. And so Microsoft and Google and all these, and Facebook itself, has a set of published principles that explains to you what to do in the event of censorship. In the case of Microsoft, it's we need you to have a court order. We're only going to shut down the blog in the country that demands it and allow it to be elsewhere, and we're going to notify where possible, and a couple other of specific guidelines that they have in place. And so, yes, I have said that I would like to see what Facebook's criteria are. I'm a little less concerned about the idea of an external reviewer. I'm comfortable with it being internal. The added benefit of having published external criteria is that they become something that the FTC and others can look to, and we can all talk about it and hold them accountable over. I think there's an ongoing debate around whether FTC's enforcement would cover this sort of egregious behavior. Incidentally, I want to say publicly that I don't think that the Facebook experimental study was terribly egregious. I mean, I think part of it is a rhetorical accident because, when manipulation is a term of art in the social sciences, which, as many of you know, it just means that it's different from the control condition, right? And then Facebook researchers were involved, and then it happens to be that the thing that they were controlling for was emotions. And so the way that the headline read was Facebook, manipulating our emotions, but actually it was a pretty common thing. But you can imagine a lot of really terrible abuses. And so, I mean, I think that the lessons from thinking about privacy as on a same sort of conversation as free speech is maybe no outside voice. Maybe you don't need an outside voice. It is, of course, different from what universities or governments will do for reasons having to do with scale and constitutional principles and so forth. But the principles are clear, and they are clearly articulated so that the community can think about them and respond to them. So I don't know if that's exactly responsive to your question, but that's what, yeah. Mm-hmm.
Yeah, no, I think it's great. My question is, if we ask companies to publish kind of research guidelines, do then they have kind of the perverse incentive to not do that if it's a voluntary program? Because if they do publish something and they don't adhere to it, are they going to maybe get in hot water in terms of enforcement from the FTC or some other body that's, assembled to govern research in the private sector? And so do we discourage them from publishing that if they could potentially get in hot water for doing so and not abiding by it? Or are there enough incentives for companies to kind of participate in a voluntary self-regulatory process?
I guess coming from my standpoint, I work with a lot of these startup companies, to Julie and Paul's conversation in the Fireside chat. And, we talk of things of CPOs, we talk of panels. These companies don't often know what a CPO is, right? If they have one, try and find one that has real authority. We live in a world where that's just not startup. That goes pretty high up the chain in terms of a lot of companies that are now having access to the tools we talk about to potentially do the things or do the research or the analysis we're talking about. And so I think this notion of having multiple different reference points out there that we can look to is important in considering those and considering if it's self-regulation, what does it look like? If it's industry regulation, which industry? That naturally requires that we have a full table. And I think by shooting too high, we potentially scare away some of these potential participants to this discussion in a detrimental way. There are a lot of fundamental tools, again, not new tools, but tools that are out there that would help. I think having a policy that promotes internal transparency, I look at what value do I bring as a lawyer to the clients I work with. It's often helping them have transparency themselves into their own organization because, believe it or not, they're moving too fast to take the time to have it, right? The right hand's not talking to the left hand. These may not sound earth-shattering. In fact, they're not. They shouldn't be. They're very basic. So this notion of having some kind of policy, having it be adherent to an industry set of guidelines, having it be something that then the company is actually making an effort to live by and operate by, I think you start to have these building blocks towards maybe this notion of fairness or ethics by design, right, where it's built into the DNA of the company. We talk about the FTC rightfully as kind of the stick in the carrot and the stick model of why would companies do this on their left to their own. I'll tell you what I've seen over the last 5 to 10 years in every transaction I'm involved with. I do technology and intellectual property transactions for a living, is very few companies that have actually involved in that transaction that have been investigated and entered into a consent decree with the FTC. But the halo effect around that is tremendous. It's the effect of the companies that have and the companies in their industry now forcing down terms in all of these agreements, these thousands and millions of agreements, that effectively make it a breach of contract, sometimes with some pretty onerous terms, to go ahead and essentially do what a company that is under a consent order with the FTC would have to do. And so you play that backwards and you look at this and you say, what's the incentive? The incentive is going to be buried in every contract that a startup company or mid-sized tech company has. It's going to be in a rep and warranty that I write or someone else gives to me and I've got to edit, because that is just the norm of the day. Breach of contract? That's something companies start to care about, especially when it's big contracts. So you don't look at that as necessarily being an outward-facing compliance mechanism. You won't know what contracts, the public won't know what contracts have those terms in them. But I think we can operate under the assumption that that's there, and there is a trickle-down effect or a halo effect to what the FTC has been up to over the last 5 to 10 years.
But I think Just a short reaction. I think there might be maybe too many lawyers on this panel, and I suffer from the same fate because the way you structure the question, like if they make a statement, then they can be held accountable for it. Maybe the FTC will step in, and you say it's about the contracts. It's not just the regulation. They're obliged by contract. I think it's much more than that. It's in these companies' interest, even if they're small startups. It's all about brand and reputation to get these things right from the start, because otherwise they're just exposed to tremendous. It's not even compliance risk, Even in a world without the FTC, the backlash can be so damaging, especially to a small startup, that it'll just disrupt their business. So I think even if they don't have a CPO or an IRB-esque structure because they're too small, and although I represent an organization of CPOs, so I should say they should have a CPO pretty early on. I think they need to take on some of these ethical, or at least rules of thumb, in order to avoid the fire.
I'd agree with that. I think that's a fantastic point, is the notion of privacy as brand is something else that is not just at the top 1%. That's not at the top 1% of the Fortune 1000. It goes down to, I sit in meetings where venture capitalists talk about that, right, with very early stage startups. So that's spot on. And again, not something that you really can legislate or I think embody an industry standard, but in terms of a function to force compliance, to force ethical behavior, oh yeah, it's there in my experience.
Incentives to compete around privacy. I mean, that's
Yeah.
what we're talking about.
Yeah.
And to go to your point, Jason, you raised something really interesting about incentives and about the push down. But it isn't only, look, I'd love it if the FTC could take credit for everything that's happening in terms of those contractual provisions. But I do think that there are, and going to your question about incentives, I think there are companies that have a lot of incentives to get these questions right, whether it's about research for the reasons that you pointed out, Omer, or whether it's with respect to big data analytics generally. I mean, if you look at Apple and what it did around its health apps, right? And the fact that it's saying up front to anyone that wants to use, to go onto its store, to use its watch or whatever, you are not going to be able to use this to get this information into the hands of data brokers. Right? This health information will have to be used kind of for the purpose that the consumer thinks it's going to be used for, and not for other purposes to profile the consumer. I mean, that didn't come from an enforcement action. That came from a lot of the things that I think people like me and others have been talking about for a long time about the sensitivity of health information, and it's being pushed down in the way that you've described, which I frankly think is a wonderful thing. I know that some people in that very long tail, that community that you're representing, or some members of it you're representing, but that very long tail probably are a little concerned about what it means for their monetization. But really, you had one company saying this is the right thing to do. We care about our brand. You need to care about your brand. This is about consumer trust. And I think it's a marvelous thing. I wanted to get to your question, though, about incentives, if I can, in another way. And Omer touched on this as well. I mean, I'm seeing a tremendous amount of activity on the part of companies and company organizations at a sort of trade group-like and entities that are trying to help companies think about how to appropriately use data. And it's not just in a research context, but it's really sort of in a broader big data analytics context where there's huge incentives on the part of companies to get this right so that they engender trust. They don't lose their brand, but they're also able to engage in big data analytics. And there's a huge conversation now around what are being called risk-based frameworks. And I want to just spend a moment talking about that because there is so much activity by companies with respect to developing this. And I think, and what it does is it actually solves the scalability problem that we were talking about, right? If you're dealing with the small companies that don't have the ability to, bring on a huge board, don't even necessarily have a CPO, and have these other scalability problems, how can they look at some of these questions around riskiness of the data collection and use that they're engaged in? I think it's helpful that these frameworks are being designed and developed, and I think that it needs to be a part of the discussion. but it cannot be the only part of the discussion. And I've been telling companies and groups that are developing this that it really can't stand alone, that we absolutely still need to be thinking about data collection, we need to be thinking about data minimization, and we need to be thinking about robust de-identification still, because you can't have these conversations divorced from all the data security concerns that we have, right? Privacy, data security are part of the same thing, and I worry a lot about a framework that would say, go ahead, collect everything under the sun, don't even worry about whether you de-identify it. We'll think of, when you start thinking about the uses that you want to put to this data, then we'll worry about whether it's risky or not. As far as I'm concerned, I think that that's a very risky approach, frankly, because of the concerns around data security. So I really want to see a risk-based framework, whether it's a research context, whether it's a big data analytics context. It needs to be married with, in my view, data minimization, robust de-identification, and when Ed Felton was our chief technology officer, were you an officer? Advisor, whatever you were. Technologist, thank you. He helped us develop, I think, some really good criteria around what robust de-identification means. And it's not just a technical solution, it's also a social solution. And I think it's great, and I really, if anyone wants to talk about it, I'm happy to. But these need to be a part of a broader conversation, or need to be a part of the way companies are going to look at appropriate data collection and use. So risk-based framework, use-based framework, great, let's talk about it, let's set up those ethical frameworks, but it's got to be in the context of overall discussion about minimizing data and de-identifying data. Otherwise, you're going to run smack dab into huge potentials around security breaches and other problems that we're dealing with all the time.
Can I agree with Julie for a second? I just want to second that. I think use-based models, as they're called now, or risk-based models, as they are presented, really create a significant risk for what Zeynep called the trust us model. We'll collect, we'll have the data, and we'll be accountable. We'll, take the precautions, and everything will be okay. I think that's incredibly risky, and essentially it cuts the individuals out of the equation. And legal and policy framework, which was created at the outset, that's what Weston had in mind, writing the FIPS 40 years ago. The system was created to empower individuals and put them at the center. If you completely sideline them with a risk-based approach or a use-based model, you've basically defeated the goal. So I think that's a risky strategy. And
to follow up on that, I also completely agree with that point, and I sort of left it out. I had it in my notes, and I just got so carried away with de-identification. It is critical to have public input into what is this appropriate ethical choice. So, whether it's Zeynep's formulation or whether it's yours or mine, I think we absolutely need to have a discussion about what goes into that black box. And companies want to be a part of that discussion. Entities that are out there helping companies develop these models also want to be part of that discussion, but the public needs to be part of it too. And in fairness, I think those in the business community, the thought leaders around these risk-based frameworks are listening to people like me. They're not sort of poo-pooing it and saying, oh my God, we can't do that, that's impossible. They're saying, oh yeah, thank you, that's absolutely right. When I first started talking to them, maybe it's been 2 years now, maybe slightly more, and I said, look, where's the public process here? Where is the conversation about what is ethically appropriate? They said, oh, you're right. It doesn't look like we're saying that, but we are. And so they're reacting and listening appropriately. But I think that this kind of conversation is incredibly important to continue to remind folks who are thinking about these models that there has to be public input. It has to be a public conversation as well.
I wanted to conceptually unpack a couple of things that we're talking about. Harry, by the way, that's another I don't know if Harry Stern and I were talking about how like words that academics use all the time, like
Unpack.
Unpack is one of those.
Academics
I
and venture capitalists.
Orthogonal and so forth. Yeah.
Orthogonal.
Yeah, it's a good one. So I'm going to push back on what Julie's saying right now. But no, in seriousness, I mean, I think conceptually speaking, there's a difference between the kinds of harms that came before under the control paradigm, the control of information paradigm, and the kinds of harms we're talking about today that the FTC has well recognized around the prospect of discrimination and over-influence and so forth, right? So and there's nothing mutually exclusive about a FIPS-based framework with data minimization and so forth, and some of the more Belmont-like principles of fairness and justice and so forth. There's nothing mutually exclusive about those things, but they're different kinds of harms. So the idea that, like, you know, a company would collect information about you and then they would sell it to some third party, or they'd get hacked because they have crappy security, right? These are specific kinds of harms that we have. But today the harms that we're talking about with the Facebook manipulation and the other examples, which I think are even better, Kashmir Hill assembled a bunch of examples of things that she thought were scarier than the Facebook manipulation study, has to do with the power that a company has over you by virtue of having so much information about you and the ability to structure every aspect of the interaction. And that's when you have to start asking questions about ethics and these questions about human rights. And these are just different sorts of questions, and they're not amenable, I don't think, to issues about, you know, data minimization and so forth, nor are they really even about risk at one level. And so I would never supplant the FIPS and other sorts of very useful paradigms. I'd like to see them evolve, be more systemic, be more risk-based. That's all wonderful. But I feel like that's distinct from some of the other things we're talking about today, and I just want to sort of point that out, you know. And you know, the basic problem is that we're treating, we said this again and again today, we're treating consumers like guinea pigs, right? And incidentally, if you do experiment on guinea pigs, there actually is a federal law against that, by the way. It's the Animal Welfare Act of 1966, and it covers guinea pigs and so forth. But the point of the matter is that, you know, I feel that's a different order, and it requires new tools, and it requires different kinds of conversations. Now, this is not to detract from anything we've been saying today, but gosh, that and I also believe, incidentally, that the Federal Trade Act, that the FTC Act, actually does allow enforcement authorities like the FTC to go after some of these things under the rubric of unfairness. Mm-hmm. But again, it just feels like these are conceptually distinct things. That's all I wanted to say.
One topic I think we'd all agree with, but I think it also bears mention, is that of certainty. When we talk about the approach, when we talk about maybe the tools that are needed to get to the rules to implement that approach, right? It's that they must lead to certainty, right? I think the explosive growth that we talk about in data in general, privacy, security, and then I throw in their rights in data, because data makes up a substantial component of shareholder value in this country, right? At least on the books. It's that if the rules, or if the tools to get to the rules end up leading to uncertainty, I think there's a detriment there, right? And there's a failure there. Ultimately to the consumers, I think more primarily to the companies that have to try and figure out how to adapt themselves to use these tools to get to rules, or an industry that has to do that for its constituent companies. At the same time, and it's a challenge, and it kind of came up a little bit in the context of the Fireside chat too, is we're not just talking about startups when we talk about needing to have flexibility, right? The medium-sized companies, the big companies, the nonprofits that are out there have to move fast to survive these days and have to change, and they're having things thrown at them all the time that they then have to process against this backdrop of, am I, in context of being ethical from a data privacy standpoint, I've just had a lot of changes to my business or a lot of changes to my world. How do I reevaluate using these tools to determine that I'm still where I want to be from an ethical standpoint? So to get to that certainty point, but also to be able to be flexible, because their world is constantly changing as well. That's not easy.
But I completely agree with that. It's a very good point, but it gets to the heart of the matter, which is, are some of the things we're talking about, having a chief privacy officer, having that be something, right? I mean, that was a big deal, incidentally, when the chief privacy officer for the Department of Homeland Security was established, and they had their own budget and their own staff. It's a big deal, and it's a big deal for reasons we all understand. Similarly, institutionally, having an individual responsible for that at the top hopefully with some real power behind them, is important. Having processes in place, like what Facebook put in place, I think is meaningful and also achievable. And so, although these things are amorphous, so is free speech. Free speech is really amorphous. What does it even mean? You know what I mean? And what does it mean to be a global company and to have free speech principles? That's and yet, there's these long documents with very specific things that the companies do, and we're all comfortable with them. We're not in a room talking about them anymore. Right? That's where we have to get, I think, with privacy. So not to disagree with you, only to say again that these are not mutually exclusive, that you can have processes and personnel and criteria in place that get us some of the direction that we want to go.
Yeah, and Ryan, you're basically preaching our gospel. You know, the IPP is a professional organization, and Deidre and Kenny Bamberger's article about privacy on the ground, that's exactly the point of privacy.
And Paul's branding privacy as well. I mean, I think, but sorry.
Right, privacy rising from the trenches and from the business need to have that process and certainty on the ground has been very important, certainly in this country, which doesn't have an across-the-board privacy law. And the results, I think, are impressive compared to other countries that do have privacy laws. So, that's basically what we say all the time. You need to train individuals in the organization to recognize what personal data is and to recognize the risks and the opportunities that it entails. That's the first step.
But let me drill down a little bit on your point about, I think you unpacked it and you put it on this side.
Oh, we're going to drill down.
Okay,
yeah.
so now we're going to drill down. I don't know if that's academic stuff.
No, it's great, Julie.
So, okay, am I working?
You're perfect, yeah,
okay,
as usual, yeah.
So, in order for an activity to be unfair, the first thing we have to prove before we ever get to the balancing test, before we ever get to the issue of whether consumers could reasonably have avoided the harm, is there has to be a substantial harm to consumers. Yep. Now, you and I had a chat, and I thought others might be interested in it. We had a chat before about some of the concerns that I have around information that's being collected about consumers who apply for payday loans online, and then where that information is going. And whether you want to call it a sucker list or whether you want to call it just a financially vulnerable consumer list, I have deep concerns, and I believe there are others in my agency who do as well, that some of that information is being used to target individuals for payday loans, and or for phantom debt collection or other financially problematic practices. Now, we will look hard at the lead generators, as they're called. That is the folks who are gathering the information and then selling it to others in terms of whether they're engaged in unfair or deceptive acts and practices. We also look very hard at the activities of the entities that are either doing the debt collection or selling the payday loans or whatever to see if they're engaged in unfair and deceptive acts and practices. But there you've got an issue that potentially hits consumers in their pocketbook, right? It is a financial harm, and we can probably prove under the right set of facts that we've met the first prong of the unfairness test. What I would need to think hard about, and this is one of the difficulties of having this conversation in the abstract, we always need a set of facts in front of us, like what are we talking about? When we talk about your concern around manipulation, I need the facts to see, would I be able to prove to a judge, or would our staff be able to prove to a judge, that there has been substantial injury to consumers? Now, it doesn't have to be financial. We have certainly taken unfairness actions when health information was inappropriately used. In fact, there was a case announced just yesterday, the Payments MD case, where we alleged that there was inappropriate population or attempt to populate consumers' health information in sort of another website, despite the fact that there actually had been some disclosure about it, that we felt the disclosure wasn't prominent enough, et cetera. So it doesn't have to be financial harm. We also brought a case against some web spying cameras, right, saying that, that invasion of the home in a way that, consumers didn't know anything about and couldn't have done anything about and it was completely different from what they thought they were buying when they bought these connected video cameras, that was also unfair. So we're going to need to look hard at any example, any case, any set of facts to figure out, will we be able to prove, that there is a substantial harm here. In the health context, I do believe that in this country we've kind of come to an understanding that health information is deeply sensitive. I think we've come to an understanding that, looking in people's homes in terms of what they're doing, what their kids are doing through video feeds, that's going to be harmful if that's going in other directions. I'm not sure that all the things you are thinking about we'd be able to prove in court. It doesn't mean that you're not, like on some global principled way, right, that it's something we shouldn't be thinking about, but we also have to think hard about how to prove it in court.
But I mean, that's one of the sort of differences between our respective hats, is that I get to pretend the law is different than it actually is. But I mean, think back. We just had a 100-year celebration of the Federal Trade Commission. Once upon a time, and it doesn't feel like all that long ago, there was authority to go after things against the public interest. And so you look at, or if you look at the Federal Communications Commission, a different agency entirely, and its statements around subliminal advertising. I wonder whether that might be a better standard today in a world where there's so much advantage taking based on information. But we live in the world we live in, and I completely agree that it's fact bound and all the things you said. And I'm encouraged by you and others and other scholars like David Gladdick suggesting that some of these the terrible abuses, that the worst kinds of abuses actually are the sorts of things that the FTC can and will pursue. And I think that does set a floor for this.
Right, and which isn't to say that we shouldn't, in those other circumstances, be thinking very hard about developing best practices and guidances and principles that can get to some of the concerns that you have. But I just wanted to make sure everybody, to sort of level set that when we are talking about unfairness, we do need to show some kind of substantial harm, which doesn't have to be financial, but it does need to be, substantial injury to consumers.
No, but I do want to point out that, Julie, you're now again talking about legally recognizable harm, so about legal enforcement. And, it's, of course, important, the work that the FTC has done to kind of expand the boundaries of the narrow definition of harms from monetary harms. But we are talking about something sort of grander than that, like what's ethically right, even if it's legal. So, you have...
Which is where best principles and practices and those kinds, and ethical training, all of that is very, very important.
Yeah.
But I heard Ryan's challenge earlier to be, I heard it very clearly, like, why aren't we using our unfairness jurisdiction with some of these cases? And I just thought it was worth spending a moment or two fleshing out what we need to do as law enforcement, which is different from the best practices.
I want to give maybe an example which you give, Ryan, the daughter killed in car crash, a category that kind of spilled out of an unfortunate mailing by whom?
Office Max.
Office Max. So, that's probably not an illegal category, and I don't think the FTC would have sort of a legal basis to pursue that on an unfairness basis. Maybe Ryan thinks otherwise, but you might still think it's unethical, or maybe not. Maybe they had like some legitimate reason to have that category in order to not send that person whatever, like happy birthday coupons for his daughter. But what I'm saying is it transcends the law, these discussions.
Well, this gets into the data broker discussion and all the entities that are behind the scenes collecting information. And we have made a very strong plea as an agency, and I have personally made a very strong plea for those entities that are profiling consumers, whether it's, killed in a car crash, or we were talking about an example up there, where people are going to be categorized in ways that feel very uncomfortable. We found some categorizations in our study, our data broker study, ethnic second city strugglers, which were, or other categories where you've got, either African American or Latino single parents who are living in cities who are trying to make it and aren't making a lot of money. Now, that kind of categorization is, whether it's called that or whether it's called now Gouda cheese, the labels are going to be changed. but those categorizations and those profiles are out there and they exist. The question is, how are they being used? Killed in a car crash is probably the most extreme example, but if we can hypothesize that that information Office Max didn't come up with that information.
Right.
It bought it from someone. And so the question is, how is the information, part of the question is, how is the information being used? But another big part of the question is, how transparent is this entire enterprise of gathering information and profiling consumers? And I've been making a call for a long time about the need for the data broker industry to be much more transparent, to provide tools to consumers so consumers can say, I don't want you to profile me. Or even for benign profiling, whether it's your dog lover or a cat lover, I don't want you to profile me in that way. I don't want you to advertise to me or give that information to others to advertise to me in that way. But for these more sensitive types of categorization, I absolutely think that creation of health information, health categories, people who suffer from diabetes, people who suffer from mental health problems, all of that is out there. Information is being collected along those lines. I think there needs to be much more robust information going to consumers, and it's not happening now. I'd love to see legislation in this area. But in the absence of that, I think we are talking about best practices. We're talking about data brokers stepping up to the plate and being more transparent about what they do.
And you're talking about a multi-tiered system there, obviously,
Absolutely.
right? It's the brokers of the brokers of the brokers, right? I mean, there was
Absolutely.
a recent list of, and I forget what the title was, but essentially was who holds the most data about American citizens, right? From an advertising context. And I think
NSA.
well, everybody knows that, right? Although I don't know that they're advertising. I suppose you could call it that, but
Who was the winner?
well, the top two, I think, were Facebook and Google in terms of, or it may have been Google. I don't know if Facebook was on the list. But the point there is that when you go beyond the top or the top two into the top 10, I bet 95% of the people here have maybe heard of one of those companies, right? And it's not a notion, I think, of the industry ratting each other out, but I almost wonder if that's where in the absence of legislation, for practical reasons, you start to talk about ethically, look, if I'm trading data for a profit, do I not look at just what I can do to monetize my data through the chains that ultimately get into the hands of an organization like a consumer company, Office Depot, Office Max, the Target study comes to, or the Target issue comes to mind from a couple years back. What do I do as a company ethically to say I'm still going to make money at that, I'm still going to have shareholder return, but I'm going to make sure I know where this data is going, right? I'm going to make sure that when in conveying these rights and this data, I'm actually putting some boundaries on this, right? That don't stop my business model, that maybe promote my business model, but that help create that link, that one link in the chain that ultimately leads to not having the use of data we'd like to stay away from when it ultimately gets into the hands of the consumer organization.
I do want to save time for questions for the audience, so I guess we'll open it up to you guys now. If there is a student left somewhere who has a question, I have to honor
They're
this.
all studying for
I
finals.
know.
Think quick about your next question.
Think quickly. You're on the spot.
It's a little unfair because he's been organized.
Designated student.
COVID, I wonder if you might have a question for this illustrious panel.
Put you on the spot or anything.
Yeah, not at all.
I thought he was safe.
Exactly.
Think fast, Coben.
I was for the day, not a student.
Pass it.
So you talked a lot about the anonymizing of the data and how that would be on the company side. Is there a way to maybe give that power to the user so that the user on the front end would be able to go in somewhere and say, I don't want my data to be associated with me. I want to opt out of this. Is that an option at all, or would there be some way to carry that out?
Well, there are some tools. Tor, anonymous browsing.
You might want to take a look at Julia Angwin's book. She kind of goes through, there's probably lots of other books. She happens to be a friend of mine, and I think also a great writer. Kashmir may have other publications on this, but there are a lot of people who sort of have put out information for consumers or citizens about how to try to be more anonymous. Now, Julia went through, I think it was like a year, trying to be an anonymous person in this data-driven world, and she's also a techie as well as a great writer. And her bottom line was it was really hard for her, and if it's really hard for her, you can imagine how hard it is for your average citizen. But if you're interested in it, and this is, I do there are people out there, and Julia talks about Tor, and she talked about a whole bunch of other tools that she'd used, and I think more and more are coming online. But I don't want to make it sound like I think it's easy.
Yeah, but there's a sort of a whole literature about user-centric identity measures and what's generally referred to as PETs, privacy-enhancing technologies, which really empower the user and kind of implement the principle of data minimization, which Julie emphasized is still very important today. Actually, I have an article with a couple of colleagues, Claudia Diaz and Sara Gurses, about the political economy of pets and why they're not as prevalent as maybe we'd like to see. Jonathan Mayer also wrote about it. So it's a developed area.
She had one.
Sorry, I came up with a question. Earlier, you guys were talking about how there are several things that are probably legal but aren't necessarily ethical. I was wondering, I know there's some associations like the Bar Association, for example, that has its own ethical standards and there can be sanctions for that. I was wondering, does business have something similar to that? If it does, how do you think it's doing? And if it doesn't, do you think it should have one?
Well, I think they're being developed. As I said, those are some of the risk-based frameworks that I was talking about. I think you're raising, though, a question that I've been talking about, and I think there are probably people in the audience, Ed among them, who could answer this better. But one other area that I think is ripe for development is an engineer's code of conduct, and whether or not engineers who are really involved in this process are thinking about their work in an ethical way. I'm actually quite comforted to hear from a number of people, including people at really, who were at really high levels of some really big companies, that there's a lot of competition now among the biggest companies in Silicon Valley to get the best and the brightest engineers. And one of the ways that they're working to attract companies is to say, we do things right here. We have a good environment. We have an environment that you're going to feel proud that you work. And so whether or not there's an actual code of conduct and, or whether we can develop a stronger one for engineers is one thing, but I do think companies are kind of, again, because of competition, going back to competition for privacy, competition for engineers is sort of driving some of this conversation. That may not be going to the long tail of companies that we were talking about before, some of this, but that would be something I'd love to see.
But I think it could go to the long tail. There's maybe an analogy
That
here
could be.
with the last 15 years, on a microcosm, the last 15 years of open source software compliance, right? Late 1990s, you didn't really see a lot of the ethics of compliance there. It was the sky is falling kind of legal, end of the earth kind of thing that never came about. And what you saw gradually was not only companies who were actually told by their engineers. I mean, I have multiple examples of clients where, why are you doing this? Or engineers said they wouldn't work for us unless we did this, right? Now, that didn't happen overnight. That grew.
Right.
But you look at it, in the history of things, that was 10 or 15 years ago. That didn't take all that long for that to come up, whereas now I think you have, engineering-wise, my experience, a very strong culture of compliance there.
Yeah, and so maybe in that you don't, anyway, it's just an area to explore and think about.
Well, we have a project going on at the University of Washington at my lab that is seeking to develop curriculum in order to inject ethical principles into early engineering education, right? Because today, I mean, maybe it wasn't in the early days, people just like learned from a book and by coding and breaking stuff and so forth. But today, engineering training is is pretty rigorous and pretty formal. And so at the University of Washington, we have a huge undergraduate and multiple graduate schools that do this stuff. And we're trying to think through, like, how do we get these folks when they're students and instill some of these values so that then they make the demands that we're talking about here.
I saw a hand there. Yep.
So a few of you mentioned just sort of marketplace discipline and branding being an issue in sort of implementing privacy norms, and then Jason also spoke about sort of contractual effects. I was just sort of wondering how realistic that is, because I think the bandwidth of both consumers and lawyers is strained. So whether those are realistic means for establishing norms, and then Ryan mentioned the sort of proliferation of First Amendment criteria within companies, and I was wondering if like how that sort of came about, because I think they're sort of similar, but I don't know.
I don't know much about the history of it, unfortunately. I mean, I just know that, companies grew up in the United States, they went global, they had a certain set of values, like privacy, free speech values, and suddenly they confronted things that they made them uncomfortable, like having to censor people and so forth. And so they felt it incumbent upon themselves, and there was additional pressure from various quarters. Not legal pressure, actually. The legal pressure ran the other way. The legal pressure was for them to do what these various states required. And then they started to move together. They formed certain arrangements together, and they copied one another. And now I think we have a relatively robust set of best practices around what to do about internet censorship. And people still worry about it, complain about it, are concerned about it. So yeah, I mean, it was rather organic the way it grew up, and I don't think that it will be quite so organic here. I do believe that there's more prodding that needs to take place. But I'm hopeful that if we can elevate privacy to the same status, and incidentally, a lot of other cultures do, I mean, we're sort of outliers and not equating free speech principles with privacy principles here, then we could get to the same place. Through some mysterious magic. I'm going to put this out there, and then Omer is going to explain how that's going to happen. But I mean, just I believe that if we were to elevate it, I'm increasingly of the view that we are elevate privacy to a civil right. That some of these things would follow more naturally.
No, but I think it's not only realistic, I think it's happening. And I'm sure Jason sees it with his clients and with entrepreneurs and startups and VCs that, if they open their eyes and they see this covered by Kashmir and by, the New York Times and the Wall Street Journal, almost on a weekly or dare I say daily basis, these privacy stories and certainly security stories, and the FTC comes in with enforcement. I mean, if they're diligent, they'll take it into account from the start, because otherwise it'll come back to haunt them at some point.
And it will, right? There is a closed loop in that it does come back to haunt. I mean, I could share any number, dozens of stories. One that I think was great is I typically think of most banks as not being too interested. They may be interested in their consumer privacy of the people who are putting money in the bank. I'm talking more of a bank lending money to a startup company or to a technology company. And this was a bank, and a well-known technology bank, and got into a very large discussion with an executive there around what they can be doing to be concerned about this issue as a risk issue for the companies that they're extending credit to. And we're talking tens of hundreds of millions of dollars of credit, right? We're not talking about a home loan or something like that. We're talking business to business. Go back 20 years and the same conversation was happening around what can we do to deal with dealing with risks that might come up of a tech company being susceptible to intellectual property infringement. Being susceptible to not having its IP properly protected. Now, fast forward today, and that's commonplace. That you don't even, if that were missing from a lending document, I would be shocked, right? Some VP at a bank would lose their job, right? The conversation is happening, right? And it's good for business. That's why it's happening. I don't care that it's great that it's good for business. My clients are in business, right? That's how they pay me. I think it also has secondary effects that I think touch on a lot of this too.
Sorry for interrupting
No
you.
problem.
I've actually heard of some of these questions, and I won't even drill down due to confidentiality.
Maybe unpack.
Unpack, not drill? Okay. in terms of what kinds of questions, but the number of the questions that you've heard here today are actually coming up in an M&A context. So that parties that are seeking to buy other parties are asking, what are you doing about this issue before I buy you? So again, a different type, very different type of market discipline, but clearly an important market discipline as well.
I think we have time for one more question, and I saw a hand early here. Yes, you're here.
It's
Hi, this is for Julie mostly, but I suspect Omer might comment as well. You started your fireside chat portion out by talking about watching out for the little guy, the consumer, that person that's not in the room. There seems to be kind of reputation that that happens more in Europe, that there's stronger privacy laws there, that there's more faster advances in credit card protection, more anti-monopoly actions, that kind of thing. I wanted you to comment kind of on how they handle things there versus the U.S. and if there's some collaboration or discussion about how things could change more to that model if you think that's appropriate.
That's a really big question. It's a really interesting question. So I'm not going to be able to nearly do it justice in the couple of seconds I have. You know, and I've given, 30-minute speeches on this issue. There's a lot that we actually share with the European model. And there are lots of ways in which the new regulation that is undoubtedly going to be passed in some form or another, they actually are modeling some of the things that we've done well here in the United States, like around children's privacy and around data breach notification. They've looked at what we're doing, and that's going to be part of their regulation. But it is true that we do not now have a black letter baseline privacy law. I advocate for one. I wish we did have one. I don't think right now Congress will have the bandwidth to do it, and so what we do have is the FTC Act, and then we've got sector-specific laws, and then we've got the state AGs. So in the context of what we have, I actually think we do enforcement really well here. And I think what happens in Europe is there's much more reliance on, well, companies must be following the law because this is what the law says, and there isn't as much of a culture of enforcement as we have here. Which is better or not? And I'm a longtime law enforcement person. I actually think law enforcement does have the halo effect that Jason was talking about and has a lot of benefits. I also think that it helps guide best practices. How do you stay out of that law enforcement context? And I think we've had a lot of conversation in this country about companies developing best practices that might not have taken place in the absence of a law enforcement culture. So, I think that there's a lot to be said for the system that we have here. Can it be improved? Absolutely. We need data security legislation like nobody's business. We absolutely should have it. We should have federal data breach notification legislation, but it needs to be robust. Otherwise, there shouldn't be preemption. We need to have state AG enforcement of it. We need to have data broker legislation, in my view, and we absolutely need to have baseline privacy legislation. If we were to have some of those things that I think we absolutely need, I do think we would be a little bit closer to that model, of the European model. But we have a different culture here, which is much more of a focus on companies can do things in the gray area. It's when they step over the line and really are in that area of unfair, deceptive practices, that's when we're going to step in. That's the culture, and I think it allowed for Silicon Valley to bloom. It allowed for a lot more technology to develop than you might see elsewhere in the world. It's because it's law enforcement, but everything beyond that law enforcement is okay.
I'll just add that despite not having a law or sort of omnibus law, no enforcement agency in Europe has brought nearly as many significant enforcement actions and has struck nearly as much fear in the hearts of business managers as the FTC has here in the US. And add to that the AGs and class action lawsuits and private litigation, I think you have a lot of activity already happening.
It's a great question. It's a complex question, so thanks for asking it.
Please join me in thanking our great panel.
So before I tell you how you can have a drink paid for by Silicon Flatirons in the University of Washington's Tech Policy Lab, let me thank three more groups I didn't thank at the very outset. We'll applaud for all of them at the very end. Number one, I need to recognize the IT staff and Rex Head and everyone else who did a wonderful job all day. Number two, I want to thank my fellow moderators. This is always the proud papa moment. Two of our moderators today, Meg and Nicole, were my former students, and it's really wonderful to see them step up in situations like this. Number three, I'd like to thank you all. You've been a wonderful, patient, and great audience asking wonderful questions all day long. So let's round of applause for all three of those groups. All right. So this is a really rule-centric group. You've noticed we've got all these traditions. This one we've already talked about, but I'm going to repeat it one more time. The price of a drink in the next room is to find a student and talk to them about your career. There are 3 of them or 4 of them, so you are going to have to apply. But please do that. But otherwise, we welcome you in the next room, and there's alcohol and lots of conversation, and we'll continue this for a long, long time. So thank you very much. Thanks, man.